I'm Drew Stevenson, and this is a video for my Law and Economics seminar for our unit on evidence and the Law and Economics approach to evidence. I have another video that's sort of an overview of the topic, but here we're going to be doing a deep dive into something specific, and that is cross-examination of eyewitnesses. So if you think about all the types of evidence that we have in a trial or judicial proceeding, we have documents, we have photographs, we have videos. We may have experts who come in and talk to us about statistics, but there's also a big place in our legal system for eyewitness testimony, and cross-examination is a very important feature of eyewitness testimony, and therefore a type of evidence, what happens during cross-examination. So let's proceed. Now, I'm drawing heavily here in this video from Judge Richard Posner's textbook, Economic Analysis of Law. In his chapter on evidence, he has a little discussion about cross-examination. Judge Posner had the benefit of being both an appellate court judge. He spent many years as a judge on the Seventh Circuit Court of Appeals and was also a full-time law professor. And so this allowed him to bring his sort of first-hand experience adjudicating cases or hearing appeals into his academic writing and gave him special insights. Now, let's start with credence goods. You may remember way back at the beginning of our semester in my class, we talked about different types of goods and services. So we talked about public goods versus private goods, and we mentioned in passing there's something called club goods and then credence goods. Credence goods could be a product that you buy, and it can also be a service. So like, let's say you hire a mechanic to repair your car, or you go to a dentist to have a cavity filled. So when we call something a credence good, we mean that consumers cannot easily determine the quality of the goods or services. Certainly not before purchase, but sometimes even during use. And I'll give an example. If you have surgery done, you can't really tell a lot of times whether your surgeon is a good surgeon or not, or did a good job, just from how you feel when you wake up. If you had a medical device inserted into your body, like a pacemaker, or a prosthetic, like a knee or hip replacement, you're not going to know ahead of time, like, did you get the best type of pacemaker, and so forth? How much difference is there in quality between it and other brands, and so forth. With these types of goods, the reputation of the seller then becomes very important. Because so we have to kind of make our assessment on whether this is good medicine to take, or a good surgeon to have do your surgery based on their reputation. Now, Posner argues that eyewitness testimony at trial falls into this category, that it's at least analogous to or is a type of credence good or credence service. So hypothetically, I want you to imagine that we have a trial, and there's only one eyewitness, right? So there was only one witness. Let's say it's the victim of an accident or a crime. So the victim's completely alone when they are a criminal commits an assault or a robbery, or they get hit by a car or something like that. So we only have their testimony to go on. And if you're reading just a transcript of their testimony at a deposition or a trial, it's hard to know, is this true, right? What they're saying, does this give an accurate picture of what happened? If you just read it in terms of the text and you never got to see who this witness is, this eyewitness, how do we know they're not embellishing it or leaving things out, and so forth? So the way we decide that heavily in our legal system is the credibility of that witness. Do they have a reputation for telling the truth and being honest, or do they have a reputation for committing fraud and cheating people and things like that? How smart and observant or perceptive are they? Do they get things wrong and misunderstand situations all the time? Are they colorblind or hard of hearing? Or does it seem like their observations and perceptions are pretty reliable? So the importance of credibility for eyewitnesses in our adversarial system explains the significance of cross-examination and rebuttal. And by the way, it also explains the rule against hearsay, which is testimony that basically circumvents or short circuits effective cross-examination. So in your evidence class, you're going to have a whole unit on hearsay evidence, and we have different legal ways of defining it. You probably heard something like an out-of-court statement that's offered for the truth of the matter asserted, or something like that. But in terms of an economics analysis, hearsay is basically we're looking at evidence and not able to really make a determination about the source, the credibility of the source, at least not a cross-examination of whoever made that statement. So now this is where it kind of gets interesting. Judge Posner argues that the real social value of cross-examination is its deterrent effect. And you probably will pick this up if you take a course on trial techniques or trial practice or something, and you get a little bit of coaching in how to do a cross-examination. It's very rare that cross-examination is going to bring out some big revelation at trial or some evidence that we wouldn't have gotten any other way, right? So hopefully your cross-examination is kind of short and sweet and to the point. If you're the lawyer cross-examining a witness, you're not on a fishing expedition trying to figure out what they know at that point at trial. And instead, the cross-examination, basically the fact that it's going to happen, creates an incentive for people to tell the truth when they're on the stand or not testify at all. So here's a quote from Posner: "Because cross-examination can destroy a witness's credibility, it rarely does so in practice, and so it's mistakenly denigrated." So a lot of people if you watch a lot of trials or you're a litigator, it's easy to start to think that cross-examination is not important, and because it's a lot of times very short, very predictable. A series of 7 or 8 or 10 questions lasts a few minutes and so forth, and we don't ever get some like big revelation during the cross-examination. And so some people may think that cross-examination is kind of just a ritual that we go through that doesn't matter. But actually it does matter quite a bit, because the witness knows before they ever agree to testify or take the stand that they will be subject to cross-examination. So if cross-examination is likely to be damaging to a specific witness, that witness will probably not be called at all, or not volunteered to take the stand. And so the possibility of cross-examination basically deters perjury in an important way. Alternatively, a witness who, let's say they have to testify, or they really want to testify for the party themselves and a defendant in a criminal case, and they want to testify, a lot of times they'll try to preempt or anticipate and preempt the cross-examination by voluntarily acknowledging unfavorable points in their testimony or weaknesses or things like that, so to sort of soften the blow of the cross-examination. So if the person freely admits, like says something during their direct testimony that like, well, I could be mistaken, or I think this, but the fact is this particular detail I'm not so sure about, or they kind of preempt or anticipate that they're going to be grilled about something at cross-examination, and they will preemptively try to explain it or fill it out. And actually, sometimes that's helpful information. So the result is, even if cross-examination is very brief and reveals no new information, or does not really significantly impeach the witness, the fact that it occurs at all can deter a lot of potential perjury. In other words, the fact that you rarely have cross-examination that's devastating means that cross-examination is actually working, because the person for whom it would have been devastating is going to avoid testifying at all. In other words, if the rule is really working, or if this procedural step in evidence is really working effectively, then what we would expect is that most of the cross-examinations are actually pretty ho-hum and aren't that devastating, or don't bring out that the person is lying or something like that, because the person who was going to lie knew ahead of time that they would be cross-examined, and so they either don't testify or they decide not to lie. And that concludes our discussion of the economic approach to cross-examination of eyewitness testimony.